Welcome to PSM Speak. If you look at the agitation of the regional rural bank employees, particularly the retirees, the senior citizens among them, four important, very crucial issues that are grossly being neglected by the powers, the government, come to the fore. It's very, very bad in a democracy, in a welfare state, to ignore these four issues. We'll come to them. First, what is it that the regional rural bank employees, the retirees, are clamoring for? They demand justice. Justice before it becomes infructuous. The retirees, some 20,000 odd, my figures are of 1 year old, 2017. Now it could be more, 25,000. Of them, already 3,500 have died without getting the benefit of what they have been demanding, the justice. So they are asking pension, their support to their life. Let us first know what the issue is. Let us go briefly into the background, why these employees are asking and why they are being denied this. First, the regional rural banks, Grameen banks, or Grama banks, or Gramya banks, Gramina banks, or Ilakai banks, depending upon where they are functioning. Regional rural bank, to be brief, RRBs. These banks specialized in serving the weaker sections in the rural area have been set up in the year 1975. The principal goal, rather only the goal of these banks, was to help the farmers who are not getting access to the institutional credit. Small farmers, marginal farmers, agricultural laborers, rural artisans, whoever they are, the rural people below poverty line. And these banks were organized as scheduled commercial banks. Government of India held 50% of the stake of these banks. And another bank, which is a government's own bank, held another 35%. Directly or indirectly, the central government held 85% of the stake of these regional rural banks, and 15% was left to the state government. The reason for this 15% of state government was to ensure the state government participation, because the schemes relate to the weaker sections of that particular state. So in a sense, these banks are totally owned by the government. It should be known statutorily these are the scheduled commercial banks. But although these were scheduled commercial banks, although they were in the public sector, the staff working in these banks were denied pay parity with the other commercial banks from the beginning, in an anomalous situation, which was not acceptable, and rightly so, to the employees of these banks. So from day one, they started organizing and fighting against this injustice. It is sinister to do that, whereby the goal of the bank to serve the weaker sections, the attention of the employees were dragged on from the issue. No, how about the salaries? The people were made to work full time on the lowest rungs. For example, they used to call part-time temporary messengers. Neither they were part-time, nor temporary, nor messenger. They were paid how much? 1 rupee a day, 30 rupees a month. Not uniformly the same. In some banks it was 5 rupees. Some other bank 10 rupees, so on and so forth, though no uniformity. What about the people who are above the other employees? The other employee situation was no different. Because the salaries were not linked to the other commercial banks, they were given salaries linking to the state governments. So they got the salaries equal to the state government, which means that the staff of RRB in Andhra Pradesh were not getting the same salaries as the staff of Karnataka, West Bengal, or any other state. So this was an anomalous situation. Then they started fighting against this injustice, and they went to the Supreme Court in the 80s. And finally, the Supreme Court in 1987, I think, constituted a national tribunal. The award was binding both on the employees and the government and the banks. So ultimately, after thorough examination, the National Industrial Tribunal, for short the NIT, it has given its award in 1990, and that was implemented after considerable dilly-dallying by the government in 1991. But although the National Industrial Tribunal said that the RRB employees should be given salaries just equal to the other commercial banks, and the salary doesn't mean only the basic salary or DA salary, means salary, allowances and all the other benefits which include pension also. Whatever benefits that the employees of the other commercial banks should be given to the RRB employees, so also was in letter and spirit of the NIT award. But unfortunately, what government did, it acted in such a way that this award is limited to only basic pay, DNS allowance and some other allowances, but not all. Worse, it thought that it was only for that particular time. That particular time when the wage structure of the banking was governed by the bipartite settlement, fourth bipartite settlement, 1987, and then fifth bipartite settlement subsequently towards the end of 90. A little about these settlements. In the banking industry, after decades of their struggle, finally there evolved a system that the managements on one part, represented by the Managements Association, Indian Banks Association on one part, and the employees, the staff of the bank and their organizations on the other, they negotiate a deal and a settlement is arrived at. That's called a settlement between two parties, bipartite settlement. So first, second, third, fourth. So it was fourth, fifth they have given. When sixth bipartite settlement came in a regular course, that was not directly applied to the regional rural banks without struggle again. In fact, government appointed a committee. What is that committee? The Mahalik Committee, to again review the salary structure of the regional rural banks, violating the National Industrial Tribunal's award, which was binding on the government. And the Supreme Court directive, the NIT was an extended arm of the Supreme Court. Whatever Supreme Court says is law. And because Supreme Court appointed, whatever the award that was given was binding, because it was binding, they have implemented. Then they started digging it up again, raking up the same old issues. Then the RRB employees had no choice but to go to courts again, knock at the doors. And finally the Supreme Court said it was wrong. This is at a time when the commercial bank employees achieved pension in 1993. Before that, they did not have, all the commercial banks did not have pension, only for historical reasons, State Bank of India. And they had the pension. Then the employees were demanding, we want pension, we also want EPF and gratuity as a third retirement benefit, but it was not accepted by the managements and the government, and finally they were given pension in 1995. The agreement was in 1993. But because the attention of the RRB employees was diverted to the very basic thing, that what they have achieved after years of struggle, their attention was engaged on them. So diversionary thing. Then after that being settled, the RRB employees went to the court again. They approached several high courts. Prominent among them is Karnataka High Court and Rajasthan High Court. And in March 2011, the Karnataka High Court allowed the petition. And in September, the Rajasthan High Court. But the government, which had been saying that in principle it was agreeable for it to implement the pension, did not do that, went in appeal. Rajasthan in 2012, the division bench upheld whatever that had been allowed by the single judge bench. Thereupon, government was not willing and it went to the Supreme Court. The case is before Supreme Court now, from 2012 onwards. And Supreme Court is not against the government settling the issue by itself. Even it gave opportunity to the government. Go and talk to the employees' representatives the employees, the petitioners, and settle it amicably. But government is not willing and didn't do. And what are the objections of the government? It has again brought up the same old issues which it brought up before the National Industrial Tribunal. It said that the regional rural banks do not have the capacity to pay that. The pension scheme is not feasible. Is that correct? Okay, let us for a while, academic purpose, say that the RRBs do not have, it is wrong, the capacity. Now, but when the National Industrial Tribunal's award was allowed, 152 of 196 then existing regional rural banks were in losses. And the losses of the loss-making RRBs were increasing, while the profits of those few RRBs was coming down. And there was erosion of capital. Despite all this, the government has no other alternative but to allow, because these were government banks, they were with a purpose, they were not for commercial profit, it is for social profit, social benefit, social cost is required, and government allowed them. But today, situation is not the same. Instead of 196 RRBs, they have been amalgamated, condensed to 56 today. Out of 56, 50 RRBs are in profits. Huge profits. Profits are so high that the government is getting tax benefit itself, 1400 crore. The gross profit of these banks is about 4096 crore. They have enough reserves, 23,120 crore. Their net worth is 425 crore. Is it right that they do not have the capacity today compared to 1991 situation? Then why RRBs, even the commercial banks, when the pension agreement was arrived at in 1993, implemented in 1995, 12 commercial banks out of 19 were in losses. So the loss of the bank did not deter. Now the government wants the regional rural bank employees to contribute to the corpus. Was it there in 1993 agreement? It was not there. The staff were allowed an option either to go for pension or to continue to get the provident fund benefit. Some of them did not immediately give their option. They were allowed, a chance was given. Even then, a few more were left. And some who did not exercise their option till 2010 asked the banks for inclusion of them also under the pension scheme. It was then the issue of contributing to the corpus has arisen. In fact, if you look at the 7th, 8th and 9th bipartite settlements, whatever that has been decided to be given to the employees, the raise was inclusive of the contribution to the pension. For instance, in 9th bipartite settlement, 17.5% was the agreed rise. Actually, 11% was allowed, which means already the pension burden is factored in. But can the government evade pension like this? If pension is charity, it is a lifetime saving of the employees, say the legal experts. It is an issue of human rights, violation of human rights to deny the pension. Now the 4 issues that these RRB retirees struggle but to focus are: one is justice to the senior citizens. If people knock at the doors of the court, their 60s, the septuagenarians, octogenarians, when should they get? There should be some time limit. It should be at least within a year or 2, some reasonable. So this should be seriously thought out while bringing the judicial reforms. The second thing that is, the government should not act as an ordinary litigant. Doesn't government know that the RRB retirees are entitled for the pension? Doesn't it know that the National Industrial Tribunal award was binding? Doesn't it know that what the RRB employees are now getting is so low that the living is difficult for them? Why should it allow the people to go to the court? because the government is just acting like an ordinary litigant too. There should be some serious thinking on this. The third is the Prime Minister. Honorable Prime Minister receives the petitions. People go as a last resort to the Prime Ministers, Chief Ministers, Governors and all. Not that they have so much time as to look into each and every petition personally, but there should be a mechanism to look at them with heart and mind. Because people in desperation, as they are not getting justice anywhere, they are going there. Don't look at from just a narrow bureaucratic angle. Just to reply, acknowledge that I have received it, getting attention, forwarded to a department. Difference, no marked difference in the status quo. So it should be seriously looked into, and there should be a mechanism to increase trust of the people that at least I can go somewhere, go to my Prime Minister or to a dignitary and bring to their notice. Nowhere else I am getting justice. The fourth one is very important. The pension should be linked to the actual salary, not something notional, like 5,000, 6,500 or something like that. Even International Labour Organization said the pension should be at least half the salary. Now the dangerous trends that it is contributory, you contribute, amount be invested into in the shares market, securities market, leaving it to the vagaries, defining the contribution, not defining the benefit. So it should be an actual salary, 50% of the salary, not these notional amounts. Hopefully the RRB employees will get justice soon, and also these issues concerning the people get right attention because of the focus that they are brought in with the indignation of the RRB retirees. Thank you for watching my channel. If you have already subscribed to my channel, thank you very much. If you haven't, please click that subscribe button below. Thank you.